Kathy, I hope you're doing well. Okay. Don't know if you can hear me. Don't know if anything's working. I don't know if anything's going to work this whole stream. But that's okay. We are days away, guys. Days away. I don't know what we're going to do with ourselves once it's over, you know what I mean? But, all right, so we have Darden still doing his thing, and we should see Sheck today. So that means the defense starts their closing arguments. I don't know if we're going to see Johnny today, but we'll see. Thank you, Holly. Now let's see if you can hear the OJ Simpson trial. We're finally talking about, the murders. There we go. Ready.
This were a case of, theft or embezzlement or something like that,
It looks
you can
right.
always make restitution. But this is a very, very serious charge. 2 people are dead. And let me say that what you do in this case is entirely up to you. I mean, you're the jury. When I sit down, I sit down. I'm done. I've completed my duty. I've done what the law requires me to do. I've lived up to the oath, my oath, as a member of the district attorney's office. And we hope we presented the best evidence we could.
Son of a gun, I just thought of something. They lied to me. Okay, this was back. We started this in December of 2024. November, January, maybe February of 2025. I was told in chat that he quits during this case. He quits. He is delivering closing statements right now. I believed him. I waited and waited and waited to see when he quits. And he just simply didn't. They lied to me in chat. Chat lied to me and I believed them.
And if we didn't present the best evidence we could, don't hold that against us. I just want you to, when the time comes to go into the jury room, I just want you to, somebody just say, let's calm down, let's elect the 4 persons, let's read the law, let's take a minute, and let's just look at the evidence. I'd just like you to use your common sense when you do. When you do that, you use your common sense when you try to be objective, when you remove all the emotion out of this case, when you remove all of the sympathy and passion, and when you just look at the facts, the evidence as best you can, you'll come up with the right decision. The world's watching. Everybody wants to know what you're going to do. Marcia Clark and I know you're going to do the right thing under the law. And whatever you do, the decision is yours. And I'm glad that it's not mine. Let me turn my attention, and hopefully yours, to the defense case, if I can talk about that a little while. They put on a defense. They called 58 witnesses. And they called 58 witnesses in this case, presumably to help raise a reasonable doubt in your mind as to the guilt of this man. And you heard from some real muckety-mucks, some real big shots in the field of science and forensic science and DNA, and you heard from Henry Lee. A real impressive group of experts, I suppose. But when you consider our case, you have to consider their case as well. You have to assess the credibility of their witnesses just like you have to assess the credibility of our witnesses. And when it comes to assessing the credibility of witnesses, you apply the same standard regardless of whether it's a defense witness or a prosecution witness. You have to decide whether or not that expert testimony is worth anything or what it's worth. I hope that when you do that, I hope you keep in mind that, people made a lot of money testifying in this case. And you should consider that on the issue or question of whether or not those witnesses are biased. But study the defense case carefully. I insist that you do, as painful as some of it might be for you. But consider this. The defense that they put on in this case, it wasn't really an affirmative defense. It wasn't the kind of defense where they show you that he wasn't there, okay, at the time of the murder.
Whoa.
They never did that.
They don't have to do that. What are you talking about? What are you saying right now, sir? I thought you were a lawyer.
They never showed you that. What they did was they attacked all of our evidence. Well, not all of it. They didn't attack the domestic violence. There are lots of things that they attacked initially, only to find out, of course, only for you to find out that, well, they didn't have a chance with it. But what you really wanted to know in that defense case, and I can't talk to you directly, but I'm going to assume you're reasonable people, you have common sense, good common sense, you're all successful at life. What you really wanted to know, correct? Maybe I'm wrong, but what you really wanted to know was where was he at the time of the murders, right? Where was that Bronco? Had they proven to you that that Bronco was not at Bundy, or could not have been at Bundy, that would have been very helpful to you. Would that not have been impressive to you? Isn't that the kind of evidence you want to hear, that you want to see, credible, reliable evidence on that issue? That's the kind of evidence that raises a reasonable doubt. They didn't do that. They didn't put on that kind of evidence because they couldn't put on that kind of evidence. They don't have that kind of evidence. We all know where the Bronco was at 10:15. It
You
was at
you
Bundy.
didn't prove that. Nobody proved that. What are you
You would have
talking
liked
about?
to have known that some other person was with Nicole Brown or Ron Goldman, right? I mean, wouldn't you not have liked to have seen some evidence from some witness that the person that killed these two people was someone other than the defendant? When Mr. Cochran spoke to you during his opening statement, he talked to you about witnesses that he intended to call, and he gave you the names of those witnesses, and he told you what they were going to say. You know, and we did the same thing. I did the same thing. You know, in domestic violence, I told you I was going to call a few other people. I didn't. I think you got the point. You know, and I can't keep you here forever. Apparently, the sequestration thing is a real drag, right? And you'd like to end this experience, and I can understand that. But he promised to present to you the testimony of some witnesses who had they testified, could have perhaps raised a reasonable doubt in this case. So where are those people? Who are those people? Well, one of those people he mentioned was a woman named Rosa Lopez. You remember this in his opening statement? He said that Rosa Lopez was the maid that lived next door to 360 North Rockingham, and that she would come in here and testify that the Bronco was parked at 8 p.m. that night, the night of June 11th, that it was parked in the exact same place the police found it the next day. And that it was parked in the exact same manner. Tail sticking out. Remember that? He said he was going to present that testimony to you. He was going to call this witness. Well, where is she? Where was she? You would have liked to have heard that testimony, wouldn't you? He didn't call it. He told you about a woman named Marianne Gerches. And he told you that she would testify that she was out on Bundy Avenue and that she saw 4 men running, 2 Hispanic men, 2 white men, and that a couple of the men wore knit caps. We have a knit cap at the scene, at the death scene. And that this happened at about 10:45. That's what the defense told you they would do. They told you they would call Mary Ann Gerches to give you that information. And you may not remember all the names, but I'm sure you remember that when you heard this, that wow, the defense is going to call these people? Whoa, this is going to be some dogfight. I mean, these people are going to come in here and they're going to lay an alibi. Rosa Lopez is going to give an alibi for him by showing that the Bronco had been there all night. Mary Ann Gerches was going to come in and testify that, hey, there were other persons, other men, apparently running from the area near 875 South Bundy. A few of them wearing ski caps, consistent with perhaps the real killer, a killer other than this man here. Did they call Mary Ann Gerches? What happened to her? Where's that testimony? You'd want to hear that, wouldn't you? And right after they talked about Gerches, they talked about a man named Tom Lang, who was supposedly down the street on Bundy, who also saw somebody. They told you that Tom Lang saw Nicole Brown standing on the street at Bundy, embracing someone. And that Tom Lang, as he stood there on the street, also saw a man standing some distance behind them, a man who appeared angry, a man standing there with his hands clenched, looking at Nicole and this other person, the person she was embracing. It's right there in the transcript at page 12,255. Where is that person? We already talked about Dr. Lenore Walker. Where's Dr. Walker? He told you Al Cowlings would testify. Where's AC? He told you that the defendant was out chipping golf balls. He told you Paula Barbieri was going to come in and testify about her relationship with the defendant. Well, we didn't get Paula Barbieri. What do we get in terms of her relationship with the defendant? We got other people, people on the peripheral. The stuff you needed to hear to raise a reasonable doubt, and you're reasonable people. Never got presented in this case. It never got presented. What you got was a lot of smoke. You got people like Gertie's telling you that the crime lab isn't, you know, can't be relied on. But then the substrate controls are all clean. You got guys like Professor McDonald out doing glove experiments where he's taking his own blood and then he's putting it on a new pair of Eris gloves and he's rubbing it around like this to see if they shrink. When you look at the defense in this case, you'll see that it really isn't helpful at all. It's all smoke. It really is all smoke. And you know, you're going to have to be careful when you deal with that defense evidence. Now, some of it was pretty good, though. I mean, that stuff they did to Furman was textbook stuff from a legal perspective. But even that, you have to look and say, well, what does it do for us? It upsets us. But then you have to look at all the evidence and see how it's helpful, if it's helpful at all. They called demeanor witnesses to testify to the defendant's demeanor after the murders. And Marcia Clark talked to you about that. You know, murderers don't walk around with neon signs saying, I just killed somebody. When people do things, commit crimes like this one, especially a rage killing like this one, he will calm down. They will calm down. And they want to get away with it. He wanted to get away with it. So he certainly isn't going to do anything that's going to draw attention to himself. But they showed you these photographs. They showed you photographs of the defendant and some women at an event the night before the murders. Remember that? Because they had Carol Connor, the woman with the keyboard vest, come in and testify about the event the night before. Remember she told you that she witnessed an exquisite romantic moment between the defendant and Paula Barbieri? Well, what does that do for you? How does that help you resolve this case? It doesn't help at all, especially when you consider the fact that he and Paula had a disagreement, for lack of a better term, over his refusal to let her go to the recital the next day. But beyond that, it's a picture. He's at this big fancy event, and somebody says, will you please pose with us for a picture? Well, when somebody takes your picture, what's the first thing they say? Geez. What point is it? What good is it? What value is it in a picture like that when somebody's posing for you? And even in that video after the recital, he sees the video camera, he looks right toward it. Posed for pictures are worthless. And they call that guy McKay. Remember Mr. McKay who worked for the AARP? Was it the AARP? Or the American Association of Psychologists or something like that in Chicago. And there was a golfing event, and the defendant came to the event as the spokesperson for Hertz. And Mr. McKay and the defendant and two other gentlemen took a picture together. They're posing for a picture. Not only are they posing for a picture, the defendant is basically at work. He's a spokesperson for Hertz. It's his job to go out and play golf with these people. So how does that help you? There's nothing in the record that establishes for you and I guess Dr. Walker could have done this. Whether or not, you know, murderers have neon signs over their heads that indicate they're murdered. How do you know? How do you know? Well, whenever you watch TV, you know, you watch the news and some brutal killing happens and you know, and it's the neighbor. The neighbor did it. And they always interview the neighbors of the neighbor who did the murders. And the reporters always say, how was he? How did he act? What kind of guy was he? Oh, he was a nice guy. They always say that. You don't know. You can't tell. The testimony you heard about demeanor on the airplane and at the airport, it was a waste of your time, really. But if you want to attach some significance to it, you go ahead. It's up to you. I mean, you're the jury. I mean, the only demeanor really that's important is his demeanor that night. You know, after he got into that Bronco and headed toward 875 South Bundy. But this defense that they put on in this case, it's what we in the profession call a shotgun defense. And it's a defense as old as the law. Way back in the day, way back in the day, even back when I was in law school, old lawyers and old law professors shared with us the old school approach to a criminal defense case. And every lawyer knows this case. You're a criminal defense attorney and you have a tough case, this is what you do. You argue the law. And if the law is against you, you argue the facts. And if the facts are against you, you raise hell and blame somebody else. When the facts and the law are against you, blame the police. Blame the prosecution. Point the finger elsewhere. Create a smoke screen. And that's what they've done in this case, ladies and gentlemen. Smoke and mirrors. That's it. That's what you've got. They put on those timeline witnesses. Remember Ellen Aronson and Danny Mandel? Judy T. Lander? Pilnack. Remember Pilnack? Was she the woman
Who
that
the
had two
hell
watches?
remembers all this? Will
You
you
haven't
get
learned
on with
anything else
it?
about this case. I'm sure that you've learned that there are people who are banging at the door to get in on this case. Those people and the testimony they had to offer really wasn't helpful at all. I mean, Danny Mandel and Ellen Aronson were on a date, right? A blind date. They went to the Mezzaluna. They say that they walked past Bundy. In fact, Ellen Aronson gave an interview to the police the day after the killings. And she told the police that she passed Bundy at 11 o'clock. But once she heard about the prosecution's theory of the case, well, what did she do? She went back to the Mezzaluna. She talked to Mandel. They got together, and they attempted to reconstruct what they did that evening. She told the police she passed at 11 o'clock. Mandel told the police they passed between 10:28 and 10:32, and he knew that because he checked his watch. But even Mandel himself didn't know whether he had passed 875 South Bundy that night or not. He didn't know. He didn't know. He didn't know until, if it ever happened, he didn't know until he and Aronson got together and started putting their notes together, trying to do, as they say, to reconstruct what happened. His time in passage at 875 South Bundy contradicts her time. They got together on their story because they got together and attempted, as they say, to reconstruct what happened. What good is this testimony to you? And if they want to say they passed at 10:28 and there were no dead bodies out there, well, fine. I don't know how they can say that. I mean, they're on a date. They're looking at each other. That pathway is pitch dark, and we know that. We know that. Because when the bodies were discovered, the police were called, and Risky said he couldn't even see any bodies up that pathway. When he first arrived and got out of his car, he had to walk all the way up the pathway and use a flashlight. The only reason anybody found the bodies was because of Cato. And not Cato the human, Cato the dog. So how much attention were they paying to that particular pathway? There are lots of pathways leading to lots of condominiums on Bundy Drive. That testimony isn't helpful to you at all, but hey, do with it whatever you like. Then they called Francesca Harmon. Remember her?
Neither is his
She
closing
testified
statement.
that at 10:20, she was driving west on Dorothy. Okay, she's driving west on Dorothy, which is just south of Bundy. She got to Bundy and she made a right-hand turn. She didn't see any bodies. Then I asked her some questions. I said, well, when you made that right-hand turn at Bundy, did your headlights hit 875 South Bundy? I mean, did they sweep across the front of the condominium? What was her answer? No. I asked her, did your lights hit the gate at 875 South Bundy? She said no. And so I asked her this, well, did you tell the defense that your lights didn't hit the gate at 875 South Bundy? And what was her response? I didn't have to. They were in the car with me. They took her out on a test drive to have her show them the route she took that night. It was clearly apparent that she could not have seen what was in front of 875 South Bundy because her lights never hit the front of the location. And they called her to testify anyway. What does that say about the defense case that you heard? Well, it says they're desperate. That's what it says. We are not wedded to a 10:15 time frame, okay? The killings very well could have happened at 10:15, but it could have happened at 10:17 also. It could have happened at 10:21. We called witnesses to the stand to testify to the point in time that they first heard the wail of that dog, of Cato. Because we know that the wail was a plaintive wail. And we know that the dog was in distress. And so we know that something was happening, something very bad was happening to the dog's master. And if the dog is first heard around 10:15, I don't know. That may mean that the defendant is hiding outside and the dog here is aware of it. It may not mean necessarily that the killing happened at that specific time. It happened sometime around 10:15. We can't give you the exact time. We can't give you the exact time to the minute. If they want to push the time to 10:30, push it to 10:30. Because any way you look at it, he's still got time to get to Bundy, because we know he's in the Bronco at 10:03. He's got time to get to Bundy to do these killings and to get back to Rockingham by 10:54 or 10:45. Their witness, Robert Heitstra, told you that on a Sunday night, you could easily drive from 875 South Bundy to the defendant's house. And he knows that because Heitstra, he worked next door at the Salingers. Okay, he worked at the defendant's neighbor's house. He told you that you could drive there from 875 South Bundy with under 4 minutes on a Sunday night easy. So it doesn't make, makes us no difference. Makes us no difference at all as far as all of the timing is concerned. But they also called Denise Pilnack, the woman that wore 2 watches, and she came in here and showed you her 2 watches so that you would find her credible and believe her, but she wanted to get in on this case. Weird stuff. Weird stuff, but you, I don't know. She testified that she drove, what did she drive? No, she came home with Judy T-Lander, and she made some phone calls, and she kicked T-Lander out of her house at a certain time and all of this. And how does she, on all of that, how does she know that? Well, because 6 months after the murders, she put together this timeline. 6 months later. So how was that helpful? And then there's T-Lander, and she's describing her drive up Bundy or around or near Bundy. And you know what's weird is that when you look at T-Lander's testimony, and you look at Harmon's testimony, and you look at Heitstra's testimony, and you look at Pilnack's testimony, and you look at Aronson's testimony, and you look at Mandel's testimony, all of these defense witnesses, and what you see, what you come away with is this. These people are all at Bundy at the same time, basically, if you believe them. They are all basically on Bundy, at the intersection, or within view of 875 South Bundy. They're all there in this small area, basically at the same time. But when you talk to them, and when they testify, they all tell you they didn't see any cars. They didn't see any people walking. They didn't see each other. Mutually exclusive. They mutually exclude each other. All of that testimony, they contradict themselves. They contradict themselves. And I'm not here to say these people are lying or whatever. They may just be mistaken. I don't know. But you have to evaluate their testimony, and I just think it's important that you take note of that. And I hope as well that you'll take a look back at the timeline witnesses, if that's what we can call them, the ones that we called. Mark Storfer. He was concerned that the dog barking might wake his little boy, and so he told you what time it was. He looked directly at the clock, and he was interviewed the next day. The day after the murders. He knew what time it was when he heard the dog barking. Look back at Eva Stein. She lived in the condo directly above the walkway where the bodies were found. She lived right next door at 873 South Bundy. I believe her time was 10:20. Was it, Eva? Was it 10:20? It was 10:20. Those are the people you can rely on in terms of time. They're right there. They live there. They live right there near 875 South Bundy. So you've heard the defense and you've heard the prosecution case. And as I said before, you're going to have to make the decision in this case, and whatever decision you make, we'll live with. But after I finish talking to you today, the defense is going to talk to you, and I don't know who's going to talk to you or who's going to talk to you first. I would ask that you listen, and listen as attentively as you have listened to me, apparently. But I'm going to ask you as well that you keep in mind that as you listen to them, consider this. Hope, at least, that they can somehow extrapolate from all the evidence we've heard in this case where the defendant was at the time of the murders. If he ain't the murderer, where was he? And maybe they can tell you that based on the evidence in this case. And they put on a defense and bear in mind and insist, I think, if they can, explain to you what happened to OJ Simpson's Aris Light 70263 gloves. The gloves found at the murder scene, the same style of gloves purchased by Nicole, the same style of gloves you see him wearing in that January 6, 1992 gang photo. Where are his gloves? They called 58 witnesses. They called the maid, Gigi Garain. They called Miss Arnell Simpson. If he never owned a pair of those gloves, I don't recall the defense asking him if he owned a pair of those gloves. I don't recall the defense asking the maid, the woman who kept the closet, who put things up, who did the laundry. I don't recall them asking her if he owned a pair of gloves like that, like the ones we found at Bundy, like the one we found behind his house. And I don't recall him asking the maid whether or not he owned a pair of Bruno Magli's. This is stuff you'd want to know. Insist that the defense explain to you who kills two people wearing $200 leisure shoes. If it ain't this man, if it isn't this defendant. Ask him to explain to you why the bloody shoe prints leading away from the bodies are size 12, his size. And where did all that blood come from? And why is it that when he spoke to Tom Lang, he told Tom Lang that the shoes he wore the night before were white Reeboks? They put on a defense, and you would expect that if the man that Alan Park saw entering the defendant's house that night was not the defendant, you would expect them to have called that man to tell you that, hey, it was me. It wasn't the defendant. Right?
No, you're not right.
If
No.
OJ Simpson didn't create or cause those stumps on the wall behind Kato Kaylin's house, then who did? This is the defendant's property. And when Kaylin comes out with that flashlight, and when he finally sees the defendant sure doesn't seem too concerned about those stumps on the wall. I mean, Kato's frightened enough to grab a flashlight. He's frightened enough to tell the woman he's talking to on the phone that, hey, if I'm not back in 10 minutes, call the police. Worry about me. Or words to that effect. But when he tells the defendant about these stumps on the wall, he isn't too concerned about it. He has West Tech security. We know that because the police talked to West Tech before they entered his house. Did the defendant call the police to say, hey, I may have a prowler on my property? Did he tell Cato to? Did he call West Tech, his private security, to come check this out? Did they? No. Why not? Because he knew. The defendant knew who caused the thumps on the wall. It was him. And why did he lie to Alan Park about being asleep? He wasn't asleep. And there are a variety of questions that you ought to insist be answered, that should be answered for you by the defense before you even consider acquitting this man of these very, very brutal crimes. The whole thing with the cut on his hand, what a fluke that is. You gonna fall for that? They talk about cover-ups. That's a cover-up. That is a cover-up. Ask them to explain to you how it is, if there were two killers, how the other one got out of that bloody crime scene without leaving any evidence of his presence. A major, major question in all of this is what happened to that little black bag? Remember the bag on the driveway, at the driveway? The one that Cato offered to go get that night just before the defendant left for the airport? The defendant said, I'll get it. What happened to that bag? Has it been seen since? The defense, well, we know that some of the luggage apparently taken to Chicago by the defendant was seized by retired Judge Delbert Wong. Remember? The Louis Vuitton bag? The one the defendant came back from Chicago with, the one he gave to Robert Kardashian. You saw it on tape. What happened to the little black bag? What happened to the contents of that Louis Vuitton bag? Remember? When you look at the tape, you see Kardashian standing there in front of the defendant's house, and you can tell that that bag is full. But when that bag comes to Delbert Wong, to Judge Wong, when it's pointed out to him, when it's seized by him months and months later, there's nothing in the bag. The bag is empty. What was in that bag? Ask him to explain to you why it is that if he didn't do it, why then is there a ton of evidence pointing to him and only to him? And ask him to explain to you, hey, if this is a rush to judgment, why then did the police go out to that house 8 times prior to 1989? Why didn't they ever arrest him? And if this is a rush to judgment, why did the police stand out in front of the house, in front of 875 South Bundy that night for a couple of hours, doing nothing, as the defense has asserted, doing nothing but waiting for Van Aderen Lane? That's a rush to judgment. This is no rush to judgment. Unfortunately, this is just how things go. Those cops got out there to conduct a murder investigation, and that investigation led them to Rockingham. They followed the blood trail. Using your common sense, and when you evaluate all the evidence, you should do the same thing. Take a look at the crime scene and follow that blood trail. Because when you do, you're going to follow it right into his house, into his yard, into his bathroom, into his bedroom, right into his lap. And that blood trail went nowhere else. It didn't go anywhere else, and it didn't go to any other person. When I began this discussion with you last night, I talked to you about justice and what justice really means in this case. And it just means doing the right thing under the law. I mean, basically, that's all it means. Following his instructions. Just do what he tells you to do, the way he tells you to do it, and you'll be fine. I spent hours talking to you. And I've talked to you about the explosion, about that fuse, how the fuse gets shorter. We've explained to you that he had the opportunity and the means and the motive to do it, and that he did it. And we discussed a little bit about the smoke. We talked about the smoke the defense has put up. You have to find your way through the smoke. One of the first things they're going to tell you is the prosecution's case lasted 6 months and ours lasted 2 months. They're going to tell you that. But you just keep in mind who was cross-examining those witnesses for days and days and days about minutia. About minutia. There was a lot of minutia in this case, and you know it was, because you didn't write it down. The defense got lost in minutia in their attempt to confuse you and to raise a reasonable doubt. But let me explain justice to you this way, and then I'll sit down and I'll be quiet. The people put on their case, the defense put on their case, and I assert that the defense case is a bunch of smoke and mirrors. It's all about distracting you from the real evidence in this case. So imagine the smoke, and imagine a burning house. Okay? Imagine that you're standing in front of a burning house, and from inside that burning house you can hear the wail of a baby, a baby's cry, a baby in fear, a baby about to lose its life. And you can hear that baby screaming. You can hear that wail. And that baby's justice. This is baby justice. Now usually justice is a strong woman, but in this case, justice is just a baby. And you hear that baby, and you hear that wail, and you see the smoke, you see the defense. There's all the smoke in front of you. And you feel a sense. You have a sense of justice. And you have a sense of what the law requires. And you have a strong commitment to justice and to the law, and you want to do the right thing. Well, justice is about to perish. Justice is about to be lost. Baby justice is about to be lost, and so you start to wade through that smoke, trying to get to that baby. You've got to save that baby. You have to save baby justice. And if you happen to run into some smoke, find your way through the smoke. And if you happen to run into a couple of defense attorneys along the way, just ask them to politely step aside and let you find your way through the smoke, because the smoke isn't over, okay? The smoke's about to get heavier because they're about to talk to you. Just use your common sense. Wade through the evidence, get down to the bottom line, and please, do the right thing. It has been an honor to appear before you, and we will wait for your verdict.
Thank you, Mr. Darden. All right, let me see counsel without the court report, please. The Simpson matter, all parties are again present. Jury is not present. Record should reflect that over the noon hour, we had an informal showing of the argument boards produced by the defense. Counsel, any comment before we resume with the jury?
Yes, Your Honor. The people had a couple of objections to lodge.
Ms. Clark.
We filed with the court a couple of motions. One dealt with the potential for Mr. Cochran to mention either Detective Furman's invocation, the other, and with the potential for referral to matters contained on the tapes that were deemed inadmissible by this court. And we have proposed a remedy should such violation occur. And the defense response doesn't appear to be very responsive to the people's motion. So the people would urge the court to instruct counsel that if he does violate the court's order by mentioning Detective Furman's invocation, or if he does violate the court's ruling with respect to the content of the tapes that was deemed inadmissible by referring to them in some manner in closing argument, that the appropriate sanction, and one that would make his violation not worthwhile, not worth doing, is to say, if you do mention such a thing, this is the remedy. I will instruct the jury that Detective Furman did not plant the glove. The remedy has to be something that makes it unworthwhile for the defense to violate the court's order. Otherwise, if all it is a monetary sanction or an admonition that is improper in front of the jury, that would not give the defense incentive to abide by the court's ruling. And so the people urge the court to make sure that the defense does not violate rulings by making a sanction onerous enough so that it would not be worth their while to do so. With respect to the burden of proof chart, does the court want to hear that now?
Yes.
We filed the motion. Did the court have an opportunity to read our motion on it?
No, I have not seen that.
I think
Do you have that chart handy?
I do. Do you have an extra copy there? Did Mr. Robertson give it to you?
Yes.
Okay.
Yes. Ms. Clark.
Okay. The problem with this board is that it's extremely misleading, and it's going to confuse and mislead the jury on a matter of law. And it's one thing to draw reasonable inferences from the record and from testimony to say, we've heard this, therefore that. But there is no misinterpretation of the law that is permitted. And counsel, although counsel can ask the jury to draw unreasonable inferences from the record, and that is what he will do, I do not think there's any authority permitting counsel to ask the jury to misinterpret the law, which is what this invites them to do. By creating the impression that the burden of proof is so overwhelming, it would be unbelievable that we could get a conviction in any case if it were as stated on this chart. It's misleading in 5 ways. First of all, it contains phrases, several of them, that supposedly describe thresholds of evidence that don't exist and have never been a part of the definition of reasonable doubt. It contains the phrases highly unlikely, less than likely, probably not, unlikely, and a variety of others, as the court has seen. All of these are used to describe thresholds of evidence that fall into the category of not guilty according to the chart, but none of them find their way into the Penal Code Section 1096 definition of reasonable doubt. So it's misleading in that respect. Secondly, it's misleading because it contains terms in the not guilty range that are consistent with guilty. For example, the phrase may not be is used to describe a threshold of evidence in the category not guilty, when in fact under 290, the jury is entitled to convict the defendant if all they have is some possible doubt. Excuse me. And as the court knows, I did go over with the jury at some length the fact that a mere possible or imaginary doubt is not sufficient to raise a reasonable doubt. What this chart conveys to the jury is that mere possible doubt is sufficient. It contravenes the burden of proof by saying that certain terms, in certain of its terminologies and some of those levels, what they say is a not guilty is actually a guilty. Do you see what I mean? So, third, it's also misleading because it implies that proof beyond a reasonable doubt is absolute doubt. I mean, absolute certainty. In other words, no doubt at all. It does that by implication, by having the bottom of it not guilty or absolutely not guilty, creating the impression that the top of that, which is the burden of proof we have to carry, is absolute certainty. There's nothing in this world that could be proven with absolute certainty. That's why we have proof beyond a reasonable doubt as a standard. Yet by implication, that is what the chart seems to infer to the jury, and that's a direct misinterpretation of the law. Fourth, it's misleading because it uses terms that are synonymous, treating them like they're distinct categories. For example, the terms probably not, less than likely, unlikely, they're synonymous, but they're, in this chart, broken down as though they're separate gradations, when in fact they're all the same. Same thing with perhaps and suspected. So they create gradations that really don't exist. It's a figmentary kind of depiction of all of the levels that a person might have of belief, and so it amplifies the burden of proof unfairly. Fifth and last, the chart is misleading because the visual nature of the representation of the degrees of proof suggests incorrect and unsubstantiated numerical levels of certainty. It would imply that there is some kind of numerical level that could be attached to what constitutes guilt beyond a reasonable doubt. And the inference drawn here by the number of levels that they have, if you work it out mathematically, is that 93% equals guilt beyond a reasonable doubt. That's improper. And we don't categorize our burden of proof by mathematical probabilities or by quantities that can be mathematically defined. That would be impossible to do. It's misleading to the jury and it's improper. So we would urge the court strenuously not to permit this chart, as the jury will be misled as to what the people's burden of proof really is and as to what is meant by proof beyond a reasonable doubt. And then Mr. Mavis points out correctly, as we cited at the end of the motion, Your Honor, the Freeman case makes it very, very clear that to vary from the standard reasonable doubt instruction is a perilous exercise. And this chart varies substantially from the definition given to the jury in their jury instruction and from the definition given in Penal Code Section 1096. And for all of these reasons, because it is misleading, and because it is a very dangerous practice, and because it may very well give the jury a misimpression of what the burden of proof really is, it should not be allowed. Counsel has also previewed for us the laser shows they intend to play. What counsel has attempted to do is subvert the court's ruling concerning the video clips by using stills from videotape. And I thought the court said we couldn't do that, and yet that's what they've done. So instead of playing the moving picture, they took the video clip and just used a still from that. I don't.
My recollection, though, is that the prosecution array that was displayed to us also included static photos of persons while testifying.
Well, I thought that we were precluded from using them.
Not the static photos, no.
Oh, I didn't know that.
Yeah. It's the actual use of the videotapes. But if you want to say, this is so-and-so, this is what the person, this is who it is, this is what they testified to, that's permissible.
Oh. Okay.
All right.
Never mind.
Okay.
With respect to the,
All right.
there's one other thing, Your Honor. They showed stills of the glove demonstration with Mr. Simpson, a number of them, with him trying on the gloves in front of the jury. But there's a number of them, which is, in effect, using a video clip. Now, if they want to use that, and if the court wants to permit them to use that, then we would ask the court, in fairness, to allow us to play the whole tape, rather than just those segments being shown by the defense.
Okay. All right, Mr. Blazer, are you handling this matter?
I am, Your Honor. Let me.
All right. Good afternoon.
Good afternoon. With respect to the, I guess it's a prophylactic instruction that they want. In case we do something wrong, then this is what our punishment's going to be. I've never heard of anything like that. We know what the rules are. We know what we can say and what we can't say. And I'm sure that if we say something we're not supposed to say, they'll jump up and you'll holler at us, and whatever will happen will happen. I think it's absolutely ludicrous for us to sit here and debate whether we might do something wrong, and if we do, what should happen about it. So I think that's just a foolish motion, quite frankly. As to the charts, the burden of proof chart, I've probably used that chart in every trial I've done in the last 5 years. It's never been excluded. I've never been told by a court that I can't tell the jury what I think reasonable doubt is. They were allowed to tell the jury what they think reasonable doubt is. That's part of argument. That's what argument is for. The court reads the instruction. Those are the words of the instruction. We're entitled to say, this is how we think you should interpret that. There's nothing on there about percentages. I guess they went so far as to count up the little boxes and add them all together and divide up and say that we were going to make some argument that 93% or 7%, I guess, is reasonable doubt. That's foolish. We're not going to offer any kind of a statement like that. The Freeman case talks about the court's instruction. The last 5 years, I've also asked the court to give my own instructions on reasonable doubt, and I never get those. You always give 2.90. But I've never been precluded from saying, this is what we think reasonable doubt is. They're going to have another shot at the jury. They can get up and say, that's a lot of hooey. You shouldn't look at it that way. You should look at it this way. So I think there's nothing wrong with that chart. As to the video clips, if they want us to show the whole thing, we'll be happy to, of the glove demo.
All right, when we're talking about the glove demo, if both sides want to use that.
Well, it's not a matter that we want to use it. It's a matter that I don't think it should be allowed for either side. And what I was saying is that, they have some stills that they want to show, which are, of course, just the parts that are most favorable to them, but I think that it would be inappropriate for either side. We could have used it in our opening argument. That was the plan that we had until it was ruled that we couldn't. But the problem with the glove demonstration is that it's an active, mobile thing. If you take still shots from that, it's very misleading to the jury, and it has penalized the people because we felt we couldn't use it.
Well, my recollection is that the prosecution argued against the use of videotape because it's not the official record.
That's right.
All right.
That's right. And our position hasn't changed, Your Honor. I think the court's ruling was also that we could only, at the point that the court was saying we could use videotape, the court was saying that it can only be tape of the witness in the blue chair, and this doesn't qualify.
Well, this is not a tape of testimony. This is a picture of the demonstrative demonstration that was done. And we only had 2 stills, by the way.
When do you anticipate getting to that?
Yeah, a minute. Hour and a half.
All right, let me see it. Let me see the excerpt that you propose to use. Or the stills, I'm sorry, that you propose to use.
Stills?
Yeah.
That's it.
All right.
Submitted.
All right. Subin?
Did you take the glove photos? The only point I wanted to add, Your Honor, other than the fact that we would have used this ourselves in opening argument, is that if these photographs are misleading because they only show a portion of it, but in order to show all of it, I mean, either the clip should be shown or none of it should be shown, and I think that none of it should be shown. Counsel can argue it as we argued it, but I don't think that this is appropriate. It's certainly not the stills of failure.
All right. Thank you, counsel. All right, as far as the prosecution motion for preemptive instruction, admonition, or warning to the defense regarding Detective Furman and regarding the McKinney tapes, the court finds that to be premature. I trust that counsel know what the law is regarding appropriate argument by counsel. The evidence code is clear that the counsel may not argue or mention the invocation, and I'm sure defense counsel know that the sanction will be swift and severe, and I don't think it's necessary for the court to take any action at this time. As far as the chart regarding burden of proof, reasonable doubt, that is a very familiar chart to the court. I've seen it before. I'm sure I'll see it again. The objection to that is overruled. The objection to the clips of the glove demo is sustained. It is not part of the official record. All right, anything else? Are we ready? All right, Deputy Tarr, let's have the jurors, please.
Okay,
3:15? 3:15, and we're going to quit at 7:45 tonight.
and then it'll be 5 to 6.
5 to 6 break. Go to 7:45. Sure, Ms. Clark. All right, the record should reflect that we've been rejoined by all the members of our jury panel. Good afternoon, ladies and gentlemen. And as I mentioned to you, we had some preliminary matters we had to take up out of your presence. We're now ready to proceed with the defense argument. Mr. Cochran.
Thank
You
you
may
very kindly.
proceed.
Judge Ito, my colleagues on the defense, my colleagues in the prosecution, the Goldman family, the Brown family, to the Simpson family. Good afternoon, ladies and gentlemen. The defendant, Mr. Orenthal James Simpson, is now afforded an opportunity to argue the case, if you will. But I'm not going to argue with you, ladies and gentlemen. What I'm going to do is to try and discuss the reasonable inferences which I feel can be drawn from this evidence. At the outset, let me join with the others in thanking you for the service that you've rendered. You are truly a marvelous jury, the longest serving jury in Los Angeles County, perhaps the most patient and healthy jury we've ever seen. I hope that your health and your good health continues. We met approximately 1 year and 1 day ago on September 26, 1994. I guess we've been together longer than some relationships, as it were. But we've had a unique relationship in this matter in that you've been the judges of the facts. We have been advocates on both sides. The judge has been the judge of the law. We all understand our various roles in this endeavor that I'm going to call a journey toward justice. That's what we're going to be talking about this afternoon as I seek to address you. The final test of your service as jurors will not lie in the fact that you stayed here more than a year, but will lie in the quality of the verdict that you rendered and whether or not that verdict bespeaks justice as we move towards justice. Now, you'll recall during a process called voir dire examination, each of you were thoroughly questioned by the lawyers. You probably thought, gee, I wish they'd leave me alone. But you understood, I'm sure, that this is very serious business. Our client, Mr. Orenthal James Simpson, is on trial for his life. And so we had to be very, very careful, both sides, in trying to get people who could be fair to both sides. You'll recall those questions, that you keep an open mind, which I hope you still have even to this day, that you wouldn't be swayed by sympathy for or passion against either side in this case, that you would give both sides of this lawsuit the benefit of your individual opinion. No one can tell you what the facts are. That's going to be your job to determine. It's not a question of age or experience. We talked about that. This is one of those jobs where you kind of learn on the job. And so it's important that you fully understand that. And that's why voir dire was so very important, as we asked you all of those questions before you were sequestered, before you were actually picked. Now, each of you filled out the questionnaire, and you answered the questions honestly, I'm sure. Now, Cicero said a long time ago that he who violates his oath profanes the divinity of faith itself. And of course, both sides of this lawsuit have faith that you live up to your promises. And I'm sure you'll do that. You know, Abraham Lincoln said that jury service is the highest act of citizenship. So if it's any consolation to you, you've been involved in that very highest act of citizenship. And so again, we applaud you and we thank you as we move toward justice. One other entity or group of ladies, or two ladies that I should thank, are our marvelous court reporters. They have been patient with us. They've been here from the very beginning. We very much appreciate them and their services, and I especially appreciate them because sometimes I speak rather rapidly, and they have a tough time keeping up with me. So I trust that today, if I start to speak too fast in my zeal, Ms. Moxham and Chris will bring that to my attention. I'm sure they will. Now, in the course of this process where we're discussing the reasonable inferences of the evidence, I ask you to remember that we're all advocates. We're all officers of this court. I will recall the evidence and speak about the evidence. Should I misstate that evidence, please don't hold that against Mr. Simpson. I will never intentionally do that. In fact, I think you'll find that during my presentation, unlike my learned colleagues on the other side, I'm going to read you testimony, what the witnesses actually said, so there'll be no misunderstanding about what was said about certain key things. But remember that we're all advocates. And I think it was Ms. Clark who said, saying it so doesn't make it so. I think that applies very much to their arguments. Ultimately, it's what you determine to be the facts. It's what's going to be important. And all of us will live with that. You are empowered to do justice. You are empowered to ensure that this great system of ours works. Listen for a moment, will you, please? One of my favorite people in history is the great Frederick Douglass. He said shortly after the slaves were freed, quote, "In a composite nation like ours, as before the law, there should be no rich, no poor, no high, no low, no white, no black, but common country, common citizenship, equal rights, and a common destiny." This marvelous statement was made more than 100 years ago. It's an ideal worth striving for, and one that we still strive for. We haven't reached this goal yet, but certainly in this great country of ours, we're trying. With a jury such as this, we hope we can do that in this particular case. Now, in this case, you're aware that we represent Mr. Orenthal James Simpson. The prosecution never calls him Mr. Orenthal James Simpson. They call him defendant. I want to tell you right at the outset that Orenthal James Simpson, like all defendants, is presumed to be innocent. He's entitled to the same dignity and respect as all the rest of us. As he sits over there now, he's cloaked in a presumption of innocence. You will determine the facts of whether or not he's set free to walk out those doors or whether he spends the rest of his life in prison. But he's Orenthal James Simpson. He's not just the defendant. And we on the defense are proud, consider it a privilege to have been part of representing him in this exercise and this journey toward justice. Make no mistake about it. Finally, I apologize to you for the length that this journey has taken. But you know, when you're seeking justice, there are no shortcuts. If you were to trade places with either side, you'd want someone who'd fight hard for you and vigorously, especially if it was a person who had maintained their innocence from the very beginning of the proceedings. Some of you in voir dire talked about that. You've been involved in other cases where you felt the lawyers didn't stand up. Well, I certainly hope that in this case, on both sides, you felt the lawyers did their best to represent their respective positions, and we will continue, I'm sure, to do that, so that, although I apologize for the length of the trial, I hope and I trust that you will understand that in a journey toward justice, there is no shortcut. Finally, with regard to your responsibilities, we ask you at the very beginning to don't compromise. This is not a case for the timid or the weak of heart. This is not a case for the naive. This is a case for courageous citizens who believe in the Constitution. And while I'm talking about the Constitution, think with me for a moment. How many times you heard my learned adversaries say, the defense didn't prove, the defense didn't do this, the defense didn't do that. Remember, back in voir dire, what did the judge tell us? Judge Ito said the defense could sit here and do absolutely nothing. One of you is from Missouri, and he reminded you, who's from Missouri here? Say to the prosecution, you show us. Now, we didn't do that. But we don't have an obligation, as you'll see. You've heard from the jury instructions, and at the end I will show you some others. We don't have to do anything. We don't have to prove anything. This is the prosecution's burden. And we can't let them turn the Constitution on its head. We can't let them get away from their burden. My job, one of my jobs, is to remind you of that, and to remind them of that that's their burden. They must prove Mr. Simpson guilty beyond a reasonable doubt and to a moral certainty, and we will talk about what a reasonable doubt means. And so now, as we have this opportunity to analyze the facts of the case, I agree with one thing that Mr. Darden said. To this task, I ask you to bring your common sense. Collectively, the 14 of you have more than 500 years of experience. I know you're all young, but you multiply by 14, you won't hold that against me, I don't think. 500 years of experience. You didn't leave your common sense out in that hallway when you came in here, and we're going to ask you to apply it to the facts of this case. I'd like to comment and to compliment Ms. Clark and Mr. Darden on what I thought were fine arguments yesterday. I don't agree with much of what they said, but I listened intently, as I hope you'll do with me. And together, hopefully, these discussions are going to be helpful to you in trying to arrive at a decision. In this case, where you don't compromise, where you don't do violence to your conscience, but you do the right thing. And you are the ones who are empowered to determine what is the right thing. Let me ask each of you a question. Have you ever, in your life, been falsely accused of something? Have you ever been falsely accused? Have you had to sit there and take it and watch the proceedings and wait and wait and wait, all the while knowing you didn't do it? All you could do during such a process is to really maintain your dignity. Isn't that correct? Knowing that you were innocent, but maintaining your dignity and remembering always that all you're left with after a crisis is your conduct during it. So that's another reason why we're proud to represent this man who's maintained his innocence and has conducted himself with dignity throughout these proceedings. Now, last night as I thought about the arguments of my colleagues, two words came to mind. And I asked my wife this morning to get the dictionary out and look up two words. Two words were speculative and cynical. Let me see if I can get those words that she got from me. Excuse me one second. I asked her, as I was thinking about this case, to go to Webster's, and I want you to tell me what does it mean to speculate? What does it mean to be cynical? As I thought about my colleagues' arguments and their approach to this case and their view of this case. Cynical is described as contemptuously distrustful of human nature and motives, gloomy, distrustful view of life. And to speculate, to engage in conjecture and to surmise, is to take to be the truth on the basis of insufficient evidence. I mentioned those two definitions to you because I felt that much of what we heard yesterday and again this morning was mere speculation. Understand this, ladies and gentlemen, that none of us in this courtroom were out at 875 Bundy on June 12th, 1994, after 10:30 or 10:45 in the evening. So that everything we say to you is our best effort to piece together what took place in this case. When people theorize about things that may have been and talk to you about short fuses, you're going to see that's just that. It's speculation. People see things that are totally cynical. Maybe that's their view of the world. Not everybody shares that view. Now, in this case, and this is a homicide case and a very, very, very serious case. And, of course, it's important for us to understand that. It is a sad fact that in American society, a large number of people are murdered each year. Violence, unfortunately, has become a way of life in America. And so when this sort of tragedy does, in fact, happen, it becomes the business of the police to step up and to step in and to take charge of the matter. A good, efficient, competent, non-corrupt police department will carefully set about the business of investigating homicides. They won't rush to judgment. They won't be bound by an obsession to win at all costs. They will set about trying to apprehend the killer or killers and trying to protect the innocent from suspicion. In this case, the victims' families had an absolute right to demand exactly just that in this case. But it was clear, unfortunately, that in this case, there was another agenda. From the very first orders issued by the LAPD so-called brass, they were more concerned with their own images, the publicity that might be generated from this case, than they were in doing professional police work. That's why this case has become such a hallmark. And that's why Mr. Simpson is the one on trial. But
That's
your
not
verdict
true.
in this case will go far beyond the walls of Department 103 because your verdict talks about justice in America and it talks about the police and whether they're above the law, and it looks at the police perhaps as though they haven't been looked at very recently. Remember I told you, this is not for the naive, the faint of heart, or the timid. So it seems to us that the evidence shows that professional police work took a backseat right at the beginning. Untrained officers trampled. Remember, I used the words in the opening statement. They traipsed through the witness, through the evidence. And it was interesting because the prosecution didn't agree with that at the beginning, but later on in this trial, we heard Mr. Goldberg and talking to witnesses. He used my words, traipsing through the witnessing. That scene there at Bundy. He used our words because they understood. We knew what we were talking about. We
No, he
had demonstrated through the
didn't.
videos. They delayed unconscionably routine procedures in notifying the coroners. They didn't call the criminalists out on time. And yes, they allowed this investigation to be infected by a
Thank you,
dishonest
Zach. That was
and
awesome.
corrupt
Thank you.
detective. They did that in this case, and they may try to back away from it all they want.
We know
That is
you
very
did it.
important, as you're going to see, to this case and the resolution of my client's innocence. Because of their bumbling, they ignored the obvious clues. They didn't pick up paper at the scene with prints on it. Because of their vanity, they very soon pretended to solve this crime, and we think implicated an innocent man. And they never, ever looked for anyone else. We think if they'd done their job, as we have done, Mr. Simpson would have been eliminated early on. And so this case is not, let me say at the outset, is not about attacking the Los Angeles Police Department. We're not anti-police in making these statements. You're not anti-police. We all need the police. I just said we have so much crime in this country, we need the police. But what we need, and what we must demand, what all of us should have, are honest, effective, non-biased police officers. Who could demand less? Can any of you say that's not what we should have? And so let me tell you about how we're going to proceed here this afternoon. The defense has one opportunity basically to address you. This is after the prosecutors are finished. I will address you first. And after I'm concluded, and I will talk generally about the lay witnesses and an overview of the evidence and what you've heard. I'll strive not to bore you. I'll strive to be honest in my discussions, to be relevant, to be concise of what we talk about here. When I'm finished, Mr. Barry Scheck will come before you and address some of the forensic issues. And then finally, after Mr. Scheck finishes, I'll come back and conclude with some concluding remarks regarding what you've heard over the course of the last 2 days at any rate. Now you understand.
Flabbergasted. I don't even know what the word was that I was.
In all cases, Ms. Clark will argue last to seek to rebut that which we bring up. And presumably she won't be back up here talking about all kind of new things. Seek to rebut that which we bring up. And let me tell you in front, if she brings up anything, we may be precluded from standing up and saying, wait a minute, Your Honor, here's the answer to that. But you can then substitute your common sense, your judgment in that place. And that's required in this journey toward justice. Now, at the outset, let's talk about this timeline for the defense. I said earlier that Mr. Darden did a good job in his argument. But one thing he tended to trip over and stumble over was when he started to try to talk about our case. He doesn't know our case like we know our case. It was interesting, wasn't it? Because first he stood up and started talking about the timeline being at 10:15. Then he said, well, they didn't prove anything, but golly, well, it may have been as late as 10:30. That's interesting, isn't it? Never heard that before. You look back and see what Ms. Clark promised you a year ago. 10:15. 10:15 was all they talked about. And they were going to use, because of the incompetence of this investigation, the wail of a dog. So let
me just tell you what happened, Zach, for real. Sorry, Johnny. I know this is important. Zach, Monday, I put out a small video to tell everybody what I was going to show last night. And I had a short funneling to it. Then I put out 2 more shorts on Monday, just of the live that happened last night. And then Tuesday, 3 shorts, or 2 shorts, I can't remember now, funneling to that live. So a video and a whole bunch of shorts saying, I'm going live on Wednesday, I'm going live on Wednesday, I'm going live on Wednesday night. And I had the video of the pro se guy doing what he does, and the judge saying, stop, 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 stop. That was all to get butts in the seat in the first 5 to 7 minutes of the stream. That's all I needed. I needed an extra large amount of butts in the stream in the first 5 to 7 minutes. And it didn't just fail. It failed. There were 17 people there during that stream. So everything I did, it just completely didn't work at all. And then all of a sudden, Law Talk with Mike Reeds. and it was full. And it just, yep.
This is very, very poor investigation. But having said the defense doesn't have to prove anything, in this case, we did, in fact. And so Mr. Darden could talk all he wanted to about his theories about motive. They're just that, his speculative theories about motive. But when he came down to the end, he wasn't talking about motive, was he? He was trying to talk about our timeline. Why would he do that? Let's talk about why he would. Because the defense in this case called many witnesses who corroborate each other and who shatter the prosecution's timeline. Now, these are witnesses to a person who were known by the prosecution but discarded by the prosecution. Why? Because they didn't fit their tortured, narrow window of opportunity. So when you would visualize for me that jigsaw puzzle, where they want to reduce this case down to a jigsaw puzzle, the part that deals with opportunity is the timeline. And we're going to start off with that because in a search for truth, let's look for the truth. Not some contorted, twisted truth, but the real truth, the facts that you've heard during the course of this particular case. We think after you look at this timeline for the defense, you will agree with our earlier analysis. This is a case about a rush to judgment, a case where there's been an obsession to win at all costs, And in the words of Dr. Henry Lee, something is wrong with the prosecution's case. Let's start off with Francesca Harmon. Francesca Harmon is the lady who left the dinner party on Dorothy at about 10:20 p.m. She drove west on Dorothy and Bundy and turned north on Bundy, so she'd be heading north toward 875. She saw nothing, heard nothing, no barking dogs. It's a lady known, of course, to both sides. And so you see this graphic regarding Francesca Harmon. I think to familiarize you with that, I think at 10:20, as I understand it, that's the approximate time that you would pass by or near Nicole Brown Simpson's home there. Oh, you see it with the X mark there in this graphic. That's Miss Harmon. We followed Francesca Harmon with Ellen Aronson and Dan Mandel. Remember the two people who'd been on their first date? They'd gone to Metzaluna. They were interesting young people. I think you would find them credible. And by the way, you hold all witnesses up to the same standard. No side has a priority on the truth. These are witnesses known to both sides. We're the ones, however, who elected to call them and bring them here for you. You know how they walked home from this first date at Metzaluna, walking directly by the walkway at 875 South Bundy. And they said they passed by there. Remember, they were clear. They passed by there at 10:25. And you'll see the little kind of purple lines. Shows you the route they took. So they passed right in front of Miss Nicole Brown Simpson's home at 10:25, and you remember they continued on. So they were over on Darlington Street by 10:29. She said that it took them about 4 minutes from the time they passed 875 South Bundy to get home that evening. This was their first date, and I guess, as I recall, this was also their last date. They saw no blood. They saw no barking dogs. I submit to you, if the bodies had been there,
Maybe she found out he was a murderer on that date. Maybe.
they could have been seen. Now, why do I say that? I say that because we have a contact print in evidence. And I'm going to ask Mr. Harris, if he can, to show us this contact print. This is an item you'll be able to take back in the jury room. Now, this is a photograph taken by Mr. Rokar at night, and it will let you see, Mr. Harris gets it focused, that scene that particular night, what you could see with regard to this body. And Your Honor, you may want to cut the feed on part of this. 33 hours. Now, and this exhibit is what number, Mr. Do you have it? I believe it may be 86. I'll get it for you as soon as he takes it out here.
86 steak.
This exhibit,
We're
let me
out.
try to get into your
Sorry.
office when we first get to it.
Restaurant.
This exhibit, number 86, was a photograph that we got late in the trial from Mr. Rokar. The photographer was called by us. You see that document over there? That's a contact sheet. Remember, he talked about all of these photographs in sequence in this first roll were taken at night. This is going to be a very, very important role for you as this case progresses. This is a photograph at night of what you could see from across the street, and there were lights in and around there. And so when Mr. Darden stands up here as an advocate and tells you it was pitch black and you couldn't see anything, this is the photograph that was taken before the sun came up. This photograph was taken at night. It's not pitch black. We know also that according to the evidence, blood had flown down that walkway. There were bloody paw prints that went southbound on Bundy there. So you see that photograph? You see that photograph? Now, you can be an advocate, and we're all sworn to do the right thing. We talked about his oath. Well, your oath is also to tell the truth. It's not pitch black. We have the evidence. And I'm going to try to do that throughout. Where they have misled you or not said things that weren't correct, I'm going to try to straighten it out for you. Mr. Harris, why don't you tell the court now what that number is? So number 1369, and that's Mr. Rokar. We're going to come back to some other photographs on that, but you'll recall his testimony. And the reason why 1369 is so important is because it is undisputed that at 10:25, Mandel and Aronson walked past there. If there was blood down on that sidewalk, if that
Hi, Nina.
a killing had taken place, if there were dogs barking or wailing, don't you think, given that, if you've been out there, you'd see it. So the time has come now to stop all this folly and fantasy. Let's deal in reality and in the facts of what took place and what you can see with your own eyes. I don't want you to speculate or theorize. When I sit down, I want you to understand what the facts are of this case. Hey, Mr. Harris, you can take that down. After that, we had Denise Pilnack and Judy Tillander. You know, and I think, again, as advocates, we have a responsibility to treat all of these witnesses with respect. These people didn't ask to come down here. These people don't ask to be maligned. I don't think anybody really wants that, with the exception of one or two. And most of them were called by the prosecution. So when Denise Pilnack, lady who wore 2 watches, comes in here and tells you, I asked you to judge her credibility like you do all the witnesses. The court has instructed you. You hold all witnesses up to the same standard. You look at the reasonableness of what they have to say. You look at their bias or interest. You look at their demeanor on the stand. You use your common sense. You use your visceral reaction, if I can use that word, to make a determination of whether or not you think this person is telling you the truth. None of these people know or knew OJ Simpson. With the exception of the people who are together, they don't know each other. They're witnesses available to both sides. But in the search for truth, we're the ones who subpoenaed them and brought them in. Let's look at Denise Pilnack. She tells you that she was at home with her friend Judy Tillander. She's across the street from 875 South Bundy. She's south and across the street. You recall that. She spoke of how eerily quiet. Remember those words? It was at about 10:24 p.m. when Tillander left her house. And she remembered that because she wanted to get Tillander out of there. She'd been there all day, and she wanted to use a computer or something to type some letters. Remember that? So she went outside on the porch with Tillander, as I recall, and Pilnack just didn't come to you to tell you that. Pilnack did something else. She, and I believe, Your Honor, that's Exhibit 1237. She showed us the phone record, Your Honor. She showed us that she got on the phone as soon as Pilnack left and called her mother. Remember she said,
Thanks,
in Gardena.
Dina, thanks.
You looked there on June 12th at 10:25
I gotta
p.m.
go. I'll be right back.
She made a call to
Bye,
Gardena.
guys.
She was able to fix the exact time that her friend left. And she said to us something very interesting, that it was quiet when her friend left, and the quiet continued for at least another 10 minutes. So that would be 10:25 to 10:35 at the earliest. She says that at 10:35, it's the first time she heard dogs barking loudly that particular night. And so that she, as you will see along with Robert Heidstra, confirm each other. They don't necessarily know each other, but they confirm each other as to when this barking really began. Now, they weren't laying in bed and had been asleep like Eva Stein. They weren't like Miss Elsie Testert, who was across the street, who didn't really know what was happening. These are people who are either outside or in that area who can come in here and tell you why they remember these particular times. They were wide awake, up and about, outside, around the time when this barking took place. Then we call this man Robert Heidstra. You know, because it came out that Robert Heidstra had been talking to the prosecution. Remember what he said. Now, this is the man who's an interesting man who details cars. He's the man who is well known to the prosecution. Remember, he talked to Detective Payne almost right away during the investigations, to Payne. And he told Payne the same thing he told you during the course of this trial. Here's what he said. He says that he lives nearby, and he has these 2 elderly dogs, one of whom I recall was 14 years of age. And so these dogs walk kind of slowly. Remember that? He walks and he takes this route. And that graphic up there shows you the route he takes. Remember, he told you he left home a little bit late that particular Sunday evening. At 10:15, he leaves home. And he proceeds on this route. And you know he's in that alleyway that runs parallel with Bundy. And he knows this neighborhood. He's been doing this for more than 14 years. He knows not only the neighborhood, he knows the dogs, he knows their barks, he knows the gates, he knows when they clank, he knows all of that. And isn't it an interesting situation? Wouldn't you have thought that of all the witnesses in this trial, in this journey toward justice, this is the only witness who ever heard any voices? But they didn't call him. You know why? Because it doesn't fit in their timeline, as you're going to see. And so he tells you that, and you recall, he's directly opposite Miss Nicole Brown Simpson's condo in that alley when he hears what he believes is the Akita start barking. And that's at about 10:35 p.m. He recognizes, he says, the Akita's bark since he walks that way, that same way, each and every evening. So while in that alleyway, east of 875 South Bundy, here's a voice yell, hey, hey, hey. And he says he then hears a gate slam. Now he goes on and says that at about 10:40, 10:45, he sees this white vehicle, which he describes clearly as a van or a Jeep. Now, they would try to tell you all these things about it being some Bronco, but he never said anything about any Bronco. He said a van or a Jeep. And the important part was, that's what he tells the detective, but he says it goes southbound on Bundy, away from where Mr. Simpson would live. And could you imagine in this area, in West Los Angeles, in Brentwood, the number of white vehicles there are and must be in that particular area? But the reason why they didn't call him was because at 10:45, OJ Simpson cannot be guilty of this crime, can he? Now, how do we know that? How do we know that, ladies and gentlemen? Well, yesterday, in her zeal and advocacy, Ms. Clark tried to push the time back from 10:40 or 10:45 that Cato heard those thumps. She tried in her chart there to push it back, remember, to 10:53. Some of you probably were surprised. There's been no testimony about that. So let me tell you, let me quote for you. Counsel, this is page 19873. This is Ms. Clark talking to one of her favorite witnesses, Mr. Cato Kalin. By Ms. Clark. And what happened with that picture when the thumps occurred? The picture tilted from, that would be right to left. The picture moved. Answer, yes it did. At that point that you heard the thumps on the wall, sir, approximately how long had you been on the phone with Rachel Ferraro? Remember, he called his friend, called his girlfriend. About a half hour. Just after he went back in the house, he called his girlfriend. And so approximately what time was it when you heard the thumps on the wall? Answer by Mr. Kalin, at about 10:40. At about 10:40. Now this is the time when the dogs first start to bark over there. At about 10:40. Is that exact 10:40, Ms. Clark says? Well, what I remember, I didn't look at the clock, but around 10:40. Question, do you recall previously testifying that it was 10:40 to 10:45? Answer, yes. Question, okay, and is that correct? Answer, yes. Now, that's their witness. That's their witness. That's what he has to say. There's no question he's there. They know he's there. You know he's there. They don't call him. What about this search for truth? Can they handle the truth? You will be making that kind of decision. And so, we then know, according to this, that by the time Hydra sees this vehicle turn south on Bundy, Cato Kalin has already heard the 3 thumps on the Rockingham wall outside of his room. And you know, that's so interesting because yesterday Ms. Clark tried to change how those thumps sounded. Now remember, this is something that you will never forget probably. I won't come all the way over there, but let me just see if I can duplicate. Cato Kalin said, here's how he said those thumps sounded. 1, 2, 3. Except he used that place up there. He said they were thumps. Almost like a signal. 1, 2, 3. That's what he had to say. And of course, you'll recall that. Your notes are much better than ours, I'm sure. Apparently the prosecution, in their zeal and their obsession to win, would have you believe that Mr. Orenthal James Simpson is so amazing that he can be in 2 places at the same time, even though they're miles apart. And when Darden was talking to you today, everybody used Heitzer to say, well, on a Sunday evening, you could make it over there in about 4 minutes. And he said that? Well, in their own drive through, that Van Adder did, took between 5 and 6 minutes. You saw it. Took close to 6 minutes. He didn't tell you that again today. And if you want to get a flavor for how, we heard the word desperate a couple times, but how witnesses were treated, just ordinary witnesses, regular citizens, let me share with you a transcript regarding Heitzer. Counsel, I'm going to be looking at 36368 through 36370. This is how Mr. Darden treated this witness who helped to shatter their timeline and establish O.J. Simpson's innocence. Didn't you tell us yesterday that the voice was a youthful voice? Yeah, it sounded like a young voice. Okay. And when you heard that voice, you thought that that was the voice of a young white male, didn't you? And there was an objection, you may recall. The voice sounded like the voice of a white male, Mr. Darden said. Answer, how could I say that it is a white male? I don't know the voice. It could be anybody there. Question, did you ever tell Mr. Stevens, my investigator, that it sounded like a white male? Answer, no. You never saw Mr. Stevens come in here and say that. Never said that? Answer, I don't recall that at all. I said it was a clear voice, but never what kind of white or brown or yellow. And then there was that second voice, correct? Right. And that second voice, that voice sounded deeper than the first voice, didn't it? Answer, a little bit, but I couldn't hardly hear it with the dogs, the commotion, with 2 dogs there. It was very short. Did you ever tell anyone that the second voice was a deep voice? Answer was deep. It was deeper than the other one, then hey, hey, hey. Okay, and then we get to the question. at line 22, counsel. The second voice that you heard sounded like the voice of a black man. Is that correct? Objection. The witness, of course not. Now, you know, we can be advocates. Those questions, nobody ever came in to impeach that man. He told you he heard two voices. He told you when this took place. He told you why, because he walks his dogs. He knows that neighborhood. A search for truth, you see, their job is not to just try to convict. Their job as prosecutors is to make sure the innocent go free also, to make sure all the witnesses come to your attention, as we've had to do in this case. So you can see that these responsible citizen witnesses who came before you were oftentimes treated roughly and ridiculed and attacked by the prosecution in their obsession to win. You don't think Heister was attacked? Remember, he was asked the question, something to the effect, are you a citizen here? Because he's from France, apparently. And something about his job and his little apartment, because he's a car detailer. Everybody is entitled to dignity. That's what we fought for in this country. You don't treat witnesses who just come in here, they don't get paid to tell the truth like that, just purely and simply because they're not saying what you want them to say in your contorted version of what the truth ought to be. But you saw that yourself. I don't have to tell you about it. Interestingly enough, they chose not to mention even one of the defense witnesses in Ms. Clark's discussion of her timeline. The prosecutors noted that none of their timeline witnesses asked to be involved in this case. Well, none of the witnesses that we call asked to be involved in this case. They came forward. You saw how they were treated. But yet they told you what they observed. But perhaps the most important thing about them is these aren't any family members. These aren't people who know OJ Simpson. These are just people who happen to be out there that particular night. And I think you can now see from that graphic how they all passed by there. We tried to make it as clear as we could. It's common sense. It's common sense, just like he said. It becomes very, very clear right at the outset. So if you accept the prosecution scenario, there's not enough time for OJ Simpson to commit these murders, given the evidence that we understand. Let me just succinctly at the beginning help you understand where I'm going on this. Remember Boziak, that they like to talk about so much? When F. Lee Bailey cross-examined Boziak the first time he was here, Bailey got him to say this remarkable thing about whoever left out that back gate turned and went back the other way. It's pretty interesting because I didn't see all those prints, but that's what he says. They went back to the scene. Remember that? That's what Boziak said. Darden said this morning. The killer or killers, they went that way. They weren't in any hurry. They went that way and then came back. You take that along with the fact that the credible evidence regarding this struggle is it took between 5 to 15 minutes. And that's what Dr. Henry Lee, Dr. Michael Batten said. They not only told you that, they showed you why that was true. You know, while I'm about it, just to digress for just a moment, Mr. Darden talked this morning about calling witnesses and not calling witnesses. Isn't that interesting? Now, they're the prosecutors. They're the ones who have the burden. In the history of man runneth not to the contrary. Nobody around here can remember any time that the coroner who did the autopsy, the actual autopsies on these bodies, wasn't called by these prosecutors. What do you think that was? They didn't call the coroner. They chose instead to call Dr. Lakshmanan, who came in here. They showed you what they thought about him. They talked about this man so badly. I mean, for 8 days, we heard Dr. Lakshmanan talk to you. They talk about length of time in this trial. Let me put that in perspective for you. For 8 days, Lakshmanan sat on that stand and went through direct examination by Brian Kilburn. Check your notes if you think I'm wrong about that. Bob Shapiro got up and took 3.5 hours and demolished him because at the end of the day, Lakshmanan told you this. Well, these were deaths that were caused by stab wounds. And the time of death was between 9 and 12. You know all those discussions about big-ticket items, and when you get back in the jury room, you'll have a lot of fun trying to figure out all those red and blue marks that they drew all over the corners. They spent 8 days trashing their own corner, and they didn't call it. Now, why is that in this search for truth? They call somebody else who's not even there at the autopsies, who has the benefit of our experts, Michael Batten and Barbara Wolf, who point out to him the mistakes that Golden has made. He then runs in here and testifies about those mistakes that we had discovered. Remember, ladies and gentlemen, in this search for truth, our experts were in place right away. OJ Simpson was paying for these experts to find the killer or killers. And you'll recall the evidence that Dr. Lee, Michael Batten, Barbara Wolf were offered to them at the beginning. So the idea is that from the beginning, there was this search for truth. So I mentioned that parenthetically at this point because I think it's important. We talk about not calling witnesses. In every murder case, it's basic that you got to call the coroner. But they did a number of things in this case, ladies and gentlemen, that had never been seen before. Off the top of our heads, 4 detectives go into the scene to notify somebody who's not even the next of kin. The detective carries blood 25 or 30 miles around in his pocket. They do things that you have never heard of before. In this case, is it because it's Orenthal James Simpson? And so as we look then at the timeline and the importance of this timeline, I want you to remember these words. Like the defining moment in this trial, the day Mr. Darden asked Mr. Simpson to try on those gloves, and the gloves didn't fit. Remember these words. If it doesn't fit, you must acquit. And we're going to be talking about that throughout. So to summarize, if you take the witnesses who we presented, who stand unimpeached, and if you are left with dogs starting to bark at 10:35 or 10:40, let's say, and we know from the most qualified individuals, Henry Lee and Michael Batten, this was a struggle that took from 5 to 15 minutes. It's already 10:55. And remember, the thumps were at 10:40 or 10:45. OJ Simpson could not be guilty. He is then entitled to an acquittal. And we have talked to you, and you've heard from the court, and my colleagues talked to you about this whole idea of circumstantial evidence. I want to talk a little more about that now. We've shown you the incredible evidence that it would be impossible. OJ could not, would not, did not commit these crimes. And where you have a circumstantial evidence case, this becomes very, very important. The prosecution then must disprove our timeline beyond a reasonable doubt. And if they don't, you must acquit. He would then be entitled to an acquittal. So let's see if we can look quickly at this jury instruction, sufficiency of circumstantial evidence generally. Mr. Douglas is going to help me today. Just a second here.
Certainly.
Douglas? Now, in both places, you can see this instruction. It's called sufficiency of circumstantial evidence, evidence generally. And to be as accurate as possible, let me allude to all of it, lest I favor one portion or the other, and together we can consider it. This is the law that His Honor has already given you as relates to circumstantial evidence, which this is, in this case, about opportunity to commit these crimes. However, a finding of guilt as to any crime may not be based on circumstantial evidence unless the proved circumstances are not only, 1, consistent with the theory that the defendant is guilty of the crime, but 2, cannot be reconciled with any other rational conclusion. Further, each fact, which is essential to complete a set of circumstances necessary to establish the defendant's guilt, must be proved beyond a reasonable doubt. In other words, before an inference essential to establish guilt may be found to have been proved beyond a reasonable doubt, each fact or circumstance upon which such inference necessarily rests must be proved beyond a reasonable doubt. Also, if the circumstantial evidence as to any particular count, either one of these counts, is susceptible of 2 reasonable interpretations, one of which points to guilt, the other of which points to innocence, you, as jurors, must adopt that interpretation which points to the defendant's innocence and reject that interpretation which points to his guilt. If, on the other hand, one interpretation of such evidence appears to you to be reasonable and the other interpretation to be unreasonable, you must accept the reasonable interpretation and reject the unreasonable. I put that up at this very moment because you've just seen the timeline, which is circumstantial evidence of O.J. Simpson's innocence, because he couldn't have done the crime given this time. So under that scenario, even if the prosecution's timeline was reasonable, if they're both reasonable, I think you must agree ours is reasonable, it becomes your duty to adopt that which points towards innocence. But even further, if theirs is unreasonable and ours is reasonable, he's still entitled to an acquittal. The only way they're entitled to conviction, ours is unreasonable and theirs is reasonable. And I think you can see and understand that's not true, that shouldn't happen, that's not the facts of this case. So before I look at their timeline, let me just see if I can summarize what I believe the prosecution has tried to tell you about their theory in this case. And this is just kind of rough, but listening to them yesterday, they tried to tell you that an insanely jealous man stalks his ex-wife, stabs her and a male visitor in a murderous rage, leaves a trail of blood to his home, barely catches a plane for Chicago, in a rush to go there, leaves one glove at the murder scene and one glove behind his house. In the defense of this case, you have heard evidence about OJ Simpson's great life. Not only did he have a great life, he had a great day that day. Playing golf, comes back from being out of town all week long, comes back to go to his child's recital. He goes to that recital, prepares in the evening, gets something to eat, a hamburger. By the way, I have to stop at this point. I'm glad Ms. Clark doesn't know this, but you know, if you've ever been to McDonald's, they don't like you to bring $100 bills in there. You know, you can't get $100 bills changed there generally. So some of these things about common sense, some people don't know.
Beyond the evidence here.
Well, all right, thank you.
Proceed.
Use your common sense about fast food places. He then takes a shower, barely catches his plane in Chicago. Someone murders his wife and this male visitor for reasons unknown in this trial. Others seek to implicate him as the most obvious suspect. The investigation becomes a tragic combination of sloppy errors and cover-ups to try and achieve his conviction. Those are going to be pretty much the hypotheses that you've heard and will be hearing in this case. Under whatever scenario, based on what I've already told you in this first hour of the argument, this man is entitled to an acquittal. But let's now turn briefly to the prosecution's timeline scenario. And you heard Ms. Clark yesterday talk about this timeline and talk about these witnesses, and she relies very heavily on this Pablo Fenves. You remember him, he's one of the early witnesses who started off, I think, talking about a plaintiff whale of a dog at 10:30, and he got pushed back to 10:15. But it's interesting because now Darden, not Marcia Clark, has now come back and conceded, well, you know, maybe it really was later. They did a pretty good job. You know, so he's saying that. But Fenves told us that he, you know, he's in that alleyway, down the alleyway and across from where Nicole Brown Simpson lives. 10:15, 10:30, whatever, 10:20. Eva Stein, next door, was asleep. Claims she was awakened. You ever wake up at night? You might see the time right, you might not. She says about 10:20 or so, she thinks she hears dogs barking. Well, I presume the dogs bark throughout that neighborhood all the time. We don't know, and that's the problem. We're trying to convict somebody or set the time of death by a dog barking. Louis Karpf, her boyfriend, comes home sometime after 10:20. And then, of course, Miss Elsie Tistert, the lady from across the street, doesn't know when or what was precisely when she heard the barks. Then there's Mark Storfer. And Mark Storfer is an interesting man because you remember he's the man who always set his watch 5 minutes fast, he says, presumably. He told us here in testimony, counsel 17190, says at 10:28 is when I looked at the TV, which was a couple of minutes after I'd gotten in the room. Right? Okay. And then he talks about, I looked out the window of our bedroom that faces North Bundy to see if I could see where that dog was or what was going on. It was pretty dark, and I couldn't see anything unusual, and I couldn't locate the dog. I also looked out the west-facing window of our bedroom to see if the dog was further over to the west. We faced the alley on the west side, and I could not see anything at that time either. Now, this witness becomes kind of important, doesn't he? Because the prosecution is going to tell you that no matter what time it is, whether it's 10:40 or 10:45, or whether it's 10:15 or 10:20 or 10:25, or Mr. Darden makes this big quantum leap. The Bronco was there. Where's Mark Storfer, who looks down that alley, and what exhibit is this, Mr. Harris? Do we know? Exhibit number 38, Your Honor. This is looking northbound down that alleyway. And you recall this because we've all been out there, and you'll recall where Miss Nicole Brown Simpson's condo is located, and you'll recall that it's sitting out in the driveway there, right there. There's a black Jeep Cherokee, as I recall. And you see, this man can presumably look up this alleyway, He didn't see any white Bronco. Nobody ever tells you about any white Bronco parked back there. Doesn't tell you about any car parked back there. So when you see people tell you about mountains of evidence and oceans of evidence, their oceans soon become little streams. Their mountains become molehills when you look at the facts. And so we go on. In addition to Mark Storfer and looking up that alley and seeing nothing or seeing no car or didn't see a dog, we hear about the other witnesses who become pretty much part of the timeline. And Ms. Clark does take some licenses regarding time. She says that Mr. Goldman leaves Metzaluna, and she says about 9:50 p.m. Says he goes home and he changes clothes, that he talked to Stuart Tanner about getting together later that evening. Remember that? Talked about going to Baja Cantina out at the marina. You know, wouldn't you think it would be logical to expect if he worked all day, when he went home and changed clothes, he might have showered, he might have gotten something to eat. Especially if later on, when you hear Mr. Scheck, you look at the amount of food, undigested food, that was still in the stomach of these two victims. But in a rush to judgment, in a rush to contort these facts, Ms. Clark tells you yesterday, let's give him 5 minutes. He's been working all day. He's got to change clothes. He's got to come home. Let's give him 5 minutes or 10 minutes. Be correct. She says, let's give him 10 minutes. That seems to me to be really, really fast. And what it really is, ladies and gentlemen, is more of that speculation. She doesn't know how long Mr. Goldman was there. None of us know that. We know he changed clothes. She has absolutely no idea. But so you understand that when you look at when somebody says something like that to you. And then as part of their timeline, she tells you yesterday that there's something sinister in Mr. Simpson seeking change to buy a Big Mac from McDonald's. I suppose that if you're in this jealous rage, if the fuse is running so short, it's interesting, isn't it, to stop, go get a hamburger at McDonald's. Does that make any sense to any of you? Does it make any sense to you to drive to McDonald's? And there's no evidence that you try to tell Cato Kalin not to come. The evidence is that these two men got in the Bentley and went to McDonald's. The evidence is that while OJ Simpson is in this murderous rage, he's worried about money to tip the skycaps at the airport because he has $100 bills. So he gets $20 from Cato Kalin. What's unusual about that? Cato Kalin's living there for free, so I suppose he could give him $20. Then Cato Kalin wants to go get something to eat. And Ms. Clark says they could have gone to a restaurant. Well, you could do anything, I suppose. But the facts are they went to McDonald's to get a hamburger. O.J. Simpson ate the hamburger. Presumably, he was hungry. Now, what's sinister about that? Unless you're cynical in your view totally of this case. Cato Kalin, their witness, they called him. They turned on him. You observed him. I ask you to hold him up to the same standards you do all the other witnesses. But I ask you, don't misquote him. Tell the truth about what he had to say. And so when he says 1040, or 1040 to 1045, don't try to make it 1052. So if you believe in this prosecution's theory, there's this blood leading down to this rear walkway. And Ms. Clark told us yesterday and unveiled her theory. Here's what they ask you to believe. O.J. Simpson comes home from these brutal murders in a Bronco that he must be driving awfully fast to get back in this time frame. He parks this Bronco out there, the Rockingham gate, somehow gets in the gate, gets down the side of his house, and what did she tell you? He bumps into the air conditioning. Well, let's examine that for a minute. The evidence is that O.J. Simpson has lived at this house for 17 years. Who do you think knows this place better, or the best of all? This is his estate. This is where he lives. This is where he's raised his children. This is where he's been married. This is where he had 2 marriages. He knows this place. So as part of their fantasy, their theory, their speculation, they have O.J. Simpson walking down this walkway, running into an air conditioning. Well, he ran into the air conditioning. Where's all the bruises that he got from running the air conditioning? Where's the sound that he made? That doesn't make any sense. You see, the reason why they come up with this running into the air conditioning, because they can't say he climbed over the fence, because there's too much shrubbery there and it's not broken. And they really don't know if he could climb over the fence with this arthritis. But they have him then walking down this walkway, bumping into the air conditioning. But ladies and gentlemen, you know, we're talking about common sense here. Bumping into the air conditioning, and then he just leaves. Is that what happens? Well, let's look at this. Thank you, Mr. Douglas. You all remember this. And what exhibit is this, Mr. Douglas? Excuse me. I'll stand over here so I won't be in your way. Thank you. Under this scenario, under their scenario, while Allen Park is out here somewhere, looking over in this direction, they have O.J. Simpson rushing back, parking the Bronco out here, and somewhere or other, he gets all the way down here. Remember, Furman told you how far that was. Gets all the way down here where this air conditioning is, out here by Cato Kalin's room. You'll see this right here. And they have him running into this air conditioning, so he doesn't know his own house. And he's all the way back here, and she says the reason he's back here is because he's going to go back here and he's going to bury the knife in the clothes. Now, isn't that something? How does she know that? Just make that up out of whole cloth? Do you believe that's reasonable? Is that reasonable to you? Does anybody on this jury believe that? That's what you were told yesterday. He runs in this air conditioning, and then just, you know, he bumps into it and he drops his glove. That's what she told you. Doesn't make any sense at all, does it, ladies and gentlemen? Doesn't make any sense at all. No sound from Cato Kalin. And then what kind of, you know, the sound has always been very confusing. Maybe not to you, but to me. Cato Kalin goes, it's more like a signal than anything else. Come out here, or whatever. But those are the facts of Cato Kalin and what happened. And that's her theory. That's her reasonable, rational theory that you have to buy into, which I think that you will find to be totally ridiculous. Now remember, down this same way, there is a door into that side room there. Mr. Simpson wanted to get in his house. What would stop him from going in that side door? Who knows his house better? If he wanted to not be seen, I'm supposed that he would know better than anybody else. Doesn't make any sense. Doesn't make any sense at all, what they're now trying to tell you. And here's something else that's equally implausible. She tells you that the reason why Mr. Simpson couldn't stop and hide these clothes is because he's too famous and too well known. Remember that? She said O.J. Simpson is too famous and too well known to stop and try to hide clothes or whatever of that nature. Well, let's take that just a little bit further. Part of what makes their theory so ridiculous is it is O.J. Simpson going to get in a white Bronco that's well known in Brentwood, drive over to his ex-wife's house, park the Bronco in this well-lit alleyway that you've just seen, leave the car there, everybody knows him, knows that car. That's equally preposterous. So she can't have it both ways. He's too famous to stop and try to throw things in a dumpster, the way she put it. Isn't he equally too famous to be driving this car to go over there under these circumstances? That is preposterous. So if you believe the prosecution's theory, and they told you all this about a bloody trail, where's the blood back there, ladies and gentlemen? There's not one drop of blood. Where's the blood back there? Where's the trail that leads to that glove? And further, look at this. Look at this, ladies and gentlemen. It's not something I'm making up. You're seeing this with your own eyes. Look at the glove. Now, when that glove is picked up, remember, is there any blood on the ground? Any blood on that shrubbery? Any blood on anything there? Where's the blood? Furman and Van Adder, as we discuss them later, will say that when they get that glove, after 6 o'clock in the morning, it's still moist and sticky. Remember their testimony? Where's the blood on the ground? Where's the blood on the leaves around there? Where's any of that? That glove looks as though it's been placed there. That glove looks as though it's been placed there. If you look at A, you'll see how far it is out to the street. So their theory doesn't hold water. It doesn't make sense. And so they get mad at Cato Kalin. And they tell you why he's biased. He's just indebted to O.J. Simpson. So we just can't trust him. But yet they want you to trust him about the knocks on the wall. And he becomes part of their theory. But the theory doesn't make sense. And when you were back there deliberating on this case, you're never going to be ever able to reconcile this timeline and the fact there's no blood back there, and that O.J. Simpson would run into an air conditioning on his own property. And then under her scenario, he still has the knife and the clothes. But what did she tell you yesterday? Well, he still has the knife, and he's in these bloody clothes, and presumably in bloody shoes. And what does he do? He goes in the house. Now, thank heaven, Judge Ito took us on a jury view. You've seen this house. You've seen this carpet. If he went in that house with bloody shoes, with bloody clothes, with his bloody hands, as they say, where's the blood on the doorknob? Where's the blood on the light switch? Where's the blood on the banister? Where's the blood on the carpet? That's like almost white carpet going up those stairs. Where's all that blood trail they've been banding about in this mountain of evidence? You'll see it's little more than a river or a stream. They don't have any mountain or ocean of evidence. It's not so because they say so. That's just rhetoric. We, this afternoon, are talking about the facts. And so it doesn't make any sense. It just doesn't fit. If it doesn't fit, you must acquit. And so she has him then still with the knife, still with these bloody clothes, and then she does something very unusual. Again on the time. Remember, she gave Mr. Goldman 10 minutes to get dressed and to go over to Nicole Brown Simpson's house with this envelope. Mr. Simpson, she says, who walks in this house in the walkway, and by the way, they were wrong. She was wrong about something else again I'd like to read you. She's wrong in her description of Allen Park. If I can locate it. Allen Park says he saw this figure in the walkway only. And so that we're clear about that, let me just read it to you. I don't have to just tell you what I think it is. I'm going to read it for you. 20571, counsel, line 17. Yes, I saw a figure come down, well, not come down, but I saw a figure come into the entranceway of the house, just about where the driveway starts. So a figure come into the entranceway of the house, just about where the driveway starts. Do you see that right there, the driveway is? That's what he said. Yesterday they were trying to put it all down here and have him come, because that was convenient to their theory. That's not what the witness said. You look at the facts of this case and you'll see, not what they tell you. Continuing it on. There is absolutely no evidence at all that Mr. Simpson ever tried to hide a knife or clothes or anything else on his property. You recall that Furman, and when I get to Furman, we'll be spending some time on him, as you might imagine, but one of the things he said was that he encountered cobwebs further down that walkway, indicating, if that part is true, and I don't vouch for him at all, there's been nobody down that pathway for quite some time. And so she talks about OJ being very, very recognizable. She talks about OJ Simpson getting dressed up to go commit these murders. And just before we break for our break, I was thinking last night about this case and their theory and how it didn't make any sense and how it didn't fit and how something is wrong. And it occurred to me how they were going to come here and stand up here and tell you how OJ Simpson was going to disguise himself. Was going to put on a knit cap and some dark clothes, and he was going to get in his white Bronco and this recognizable person and go over and kill his wife. That's what they want you to believe. That's how silly their argument is. And I said to myself, maybe I can demonstrate this graphically. Let me show you something. This is a knit cap. I'm going to put this knit cap on. And you've been seeing me for a year. If I put this knit cap on, who am I? I'm still Johnny Cochran with a knit cap. And if you look at OJ Simpson over there, and he has a rather large head, OJ Simpson in a knit cap from 2 blocks away is still OJ Simpson. It's no disguise. It's no disguise. It makes no sense. It doesn't fit. If it doesn't fit, you must acquit. Good time, Your Honor.
All right, ladies and gentlemen, we're going to take our mid-afternoon recess at this time. Remember all my admonitions to you. We'll stand in recess for 15. All right, back on the record in the Simpson matter. All parties are again present. All right, we'll let the stragglers get in here. All right, Deputy Trier, let's have the jurors, please. Please be seated. And let the record reflect that we've been rejoined by all of our jury panel members. Good afternoon, ladies and gentlemen, again. And Mr. Cochran, you may continue with your final argument.
Thank you, Your Honor. Good afternoon, ladies and gentlemen. Thank you for your patience thus far, and we'll start up again and see if we can make it to dinner. When we left, just before we broke, I was sharing with you a knit hat or knit cap that we've heard so much about in this case. And it reminded me that there was testimony early on that Detective Lang had refused basically to pick up a knit cap inside the Brown residence that was shown to him, I think, by some of the lawyers and one of the investigators on that date, because these are fairly common. But they don't really disguise anybody who's noticeable, do they? And although I was the guinea pig here this afternoon, if you were to put a knit cap on, how's that going to disguise you? We've been together. I know your face anywhere now, and you know mine. And the people in Brentwood, in West Los Angeles, would know OJ Simpson. They know his car. They know him. That's where he lives. Even the prosecutors say he's so famous that he can't go anywhere where he wouldn't be recognized. Now, one of the things about this people's timeline or whatever is that you recall that some of OJ's bags were already packed outside of the house on that bench when Cato came outside to investigate the thumps, which he'd heard. And this is interesting because the prosecutors have kind of talked at cross purposes on this. Cato at some point comes out because he hears these thumps, allegedly. And he has a little tiny flashlight, or I think the court called it a pin light or a mag light or something like that. And it was something small because it's dark back down that walkway. Apparently he went part way down that walkway, and then he came back. It's interesting, isn't it? He came back, and at some point he lets Park in. I remember all these questions about opening the gate and everything. Remember, there's a dog there. Isn't there a dog there named Chachi? There's a lot of talk about these dogs, and you've heard a little bit about these dogs. But one thing that I think is, as the prosecutors make these kind of wild speculations, you now know that the Akita dog was bought by OJ, as was Chachi. Because remember, one of the dogs died, and like a good dad, he let the dog stay at the other house sometime with his son Justin, and they named the dog after Cato. Was I think the understanding of what you've heard from Arnell. But at any rate, I point that out because we know there was another dog over there named Chachi, a black dog, black chow. But while Cato is out looking for these thumps, what happens to these thumps, Mr. Simpson talks to him. In fact, they go in the house together because Mr. Simpson is going to help him look or help him find a larger flashlight. And then someone says, or he's reminded that Mr. Simpson is running late for his trip. So then he takes off. My understanding of the facts is Mr. Simpson said, I'll call you later and have you put the alarm on. Because he was getting out of there. Parks was already there. But I think the interesting thing to remember is that some of the bags were already down, including that golf bag, were already down there. This was not any unexpected trip. He started putting things down there. If you look at everything in a
I heard it
fashion,
while I was
you heard this
driving.
morning,
I heard it.
There was a knapsack over, or a nap bag, or some little bag they were talking about over in the driveway. Well, if you're a golfer, isn't it reasonable to assume there's golf balls in there? And if you put that in your golf bag, I mean, what's the big deal? Because they've got to try to theorize and try to explain everything, which they can't explain. They weren't there. They rushed to judgment. And it leads to this kind of wild speculation. You have to do that when you don't have a case. And that's all you've seen them do time after time after time. With regard to that walkway, lest I be totally clear to you, if O.J. Simpson had been the one, for whatever reason, to walk into that air conditioning, where's the hair and trace? Where's the fiber? Where's the blood? They want to tell you about his fingers bleeding 1 minute, and it stops bleeding. In Miss Clark's scenario, he bleeds, it coagulates, stops bleeding, then it starts bleeding again. Because that's convenient for her theory. You know, as I listened to both of them, I wanted to call them Dr. Clark, because Dr. Clark told you, well, gee, look at that blood drop. That cut wasn't big enough for that blood drop. She's not any doctor. How does she know that? Dr. Darden, for the love and the forlorn. He knows everything about relationships. He just speculates on and on and on. He's got this great, vivid imagination. The only thing is, this is real life. This isn't anything from Murder, She Wrote. If they tried to sell this story to Murder, She Wrote, they'd send it back and said, that's unbelievable. You're going to see that as we tie it together. But it's nice to have vivid imaginations, but not in this courtroom. Because here, you are searching for truth on this journey for justice. So we know that Cato had some concerns. He was looking around. We know that at some point, Mr. Simpson comes down the stairs carrying the Louis Vuitton bag or whatever, and then Mr. Simpson leaves about 11:02 for the airport. I think that's pretty clear based upon the evidence. And you'll recall that Ms. Clark again gives Mr. Simpson 5 minutes to rush in, according to her theory. He rushes in, changes clothes, disposes of all these clothes, showers, packs, does everything, and comes downstairs and says, composes himself. Now, can you imagine that? I mean, who do they think they're talking to? In 5 minutes, he does all these things. And then they tell you that, you know, under this post-homicidal way you act, you get yourself all composed and you just do this. This is preposterous. They're not experts. They can't testify. Those are just their wildest, rankest theories. You use your common sense when they tell you things like that. OJ Simpson was OJ Simpson, the way he always appeared by the people who knew him and talked to him. We'll talk more about that when we talk about demeanor. But the reason they can't explain his demeanor and the way he acts like he always acts, they then talk about, well, you can't tell who's a murderer. I mean, those are all real convenient words, aren't they? But they fly in the face of reasonable activity by a reasonable man on that particular night. So there's Allen Park. O.J. Simpson comes down within 5 minutes of the time they believe he goes upstairs. No time to dispose of bloody clothes. What about blood on the carpet? What about dirt on this white carpet? How does he shower? How does he get dressed? I mean, it doesn't make any sense at all, does it? Park himself says the golf bag was already packed and ready to go when he pulled into the driveway. And Miss Clark went to great trouble to tell you how credible she thought Mr. Park was and how he tried to lay everything out. And I think, by and large, we agree with that. But I think if you're going to quote Mr. Park, you ought to quote him accurately and not attempt to mislead or whatever. And so what I did was I went back to the transcript again, where Miss Clark told you and showed you that photograph yesterday about whether or not Mr. Park saw or was looking at the Bronco or looking for the Bronco on the night of June 12th. Remember that? She told you yesterday I spent a long time with him. And so I remembered that I asked him questions and his response. I asked him at some point, I'm asking you if you looked to, made an effort to see if there was a car parked. Answer, no. Was that a correct answer at that time? Answer, yes. All right, question. There might have been a car parked there and you didn't see it? Answer, correct. And the reason why you don't know one way or the other is because you weren't focusing on any cars or paying any attention. Isn't that right? And I went on to ask still another part of this question. Basically, your goal was to get Mr. O.J. Simpson, try to get him to the airport on time, isn't it? Answer.
No, he wanted him to be late. Just like we are, we're late. We went 2 minutes over. But the power didn't go out and the video played, so that's all 2 thumbs up. All right, guys. We got to hear the if it doesn't fit, you must have quit twice. So that was good. Although the description to these videos said that Sheck was coming up, not Johnny. So I was pretty shocked when Johnny started talking today. But that's fine, you know. Hey, we're getting through it. We're getting through it. It feels like we're so far, but we still have a lot of videos left. I'm just going to count the number of videos. Well, we're at 480. Well, there's 18 videos left. And it feels like we are already pretty far into the closing arguments. But, you know, it is what it is. We'll get there. Thanks for coming out today, guys. I hope you guys have a great day. And I'll see you again real soon, okay? Bye, guys.